Justice has been served 5 months after the brutal rape and murder of the Arjikar trainee doctor. The Sealdah court convicted the accused Sanjay Roy. Roy was proven guilty of rape and murder of Abhaya. The quantum of punishment will be pronounced on Monday around 12:30 p.m. Roy has been proven guilty under sections of sections 64, 66 and 103(1) of the Bharatiya Nyaya Sanhita 2023. The maximum punishment under section 66 and 103(1) is death penalty, while the minimum would be life imprisonment. The judge even hinted at 25 years of life imprisonment and death penalty. The judge has said he relied heavily on forensic and digital evidence and is beyond doubt convinced that Roy indeed raped and murdered Abhaya. This comes even as during court proceedings, Sanjay vehemently kept denying charges and alleged that he was being framed. The TMC has hailed the verdict, saying that the stance of the Kolkata police stands validated and that the direction of investigation was indeed correct. Listen in to all the political reactions.
ये कोर्ट में जो आज वर्डिक्ट हुआ है वो तो एक फेज है, क्योंकि आज उसको दोषी माना गया और पनिशमेंट क्या होगा नेक्स्ट डे पर कोर्ट अनाउंस करेंगे। इसके ऊपर अभी कोई कमेंट करना ठीक नहीं है, लेकिन ये ज़रूर साबित हो गया है कलकत्ता पुलिस आरजीकर केस ने विदिन 24 आवर्स अरेस्ट किया था वो संजय राय को। तो कलकत्ता पुलिस का जो इन्वेस्टिगेशन, कोलकाता पुलिस को जो फोकस थे वो एकदम ठीक ठाक थे, राइट वे पर थे। और उसके बाद वी वांट सीबीआई, वी वांट सीबीआई, वी वांट सीबीआई, वो लोग आज बोल रहा है कि सीबीआई के इन्वेस्टिगेशन में हम लोग सेटिस्फाइड नहीं है। अब देखिए, पहले आज ये साबित हो गया है कलकत्ता पुलिस जो इन्वेस्टिगेट कर रहे थे, अरेस्ट किए थे, वो तो एकदम सही था।
वर्डिक्ट नहीं आया है, उनको चार्ज फ्रेम किया गया है, जो वो उसको पनिशमेंट डिक्लेयर मंडे होगा, कैपिटल पनिशमेंट हो जाएगा, इसलिए चार्ज फ्रेम हो गया है। कौन इन्वॉल्व है तो सीबीआई को देखना पड़ेगा और सुप्रीम कोर्ट को देखना पड़ेगा, लेकिन उसका फैमिली और बंगाल का हर जनता का यही मांग है, जैसे डीएनए आया उसमें मिक्स्ड रिपोर्ट आया, जैसे फॉरेंसिक आया उसमें भी बहुत सारा क्वेश्चन डॉक्टर लोग भी उठा रहा है, उनका फैमिली उठा रहा है। ये सबको क्लियर करना फ्यूचर में चाहिए। ये पहला चार्जशीट है, इसका बाद बहुत सारा सप्लीमेंटरी चार्जशीट का मौका भी है। सबका उम्मीद है सुप्रीम कोर्ट और सीबीआई इसका पर्दाफाश करेगी, लेकिन आज जो हुआ उसको मैं वेलकम कर रहा हूँ।
All right, let's quickly go across to Kamalika Sengupta, who's joining us live from the Sealdah court. Kamalika, give us a sense of the way this now verdict is also being politicized, because the TMC is saying that its own stance has in fact been vindicated, while the BJP of course continues to accuse the state of having botched up the initial investigation through the Kolkata police.
Congress clearly stated today that it is Kolkata police also arrested Sanjay Roy. They arrested Sanjay Roy within 24 hours. And whatever they did in their investigation, that is what it's written in CBI charge sheet. So CBI has not done nothing extra. So, you know, the fact that this all hue and cry, that more than one people and a lot of other things, these are not right. That is the narrative that has been projected by the Trinamool Congress. So definitely it's a win situation for Trinamool. On the other hand, the BJP, they are saying that this Sanjay Roy is a civic volunteer who is a part of the police force, obviously. And they believe that there are more things will come. Because the parents, and also in High Court with certain questions, it is the CBI which has actually put the case in such a manner, they have done the investigation in such a manner that Sanjay Roy is convicted, so CBI has done their job. But the most important point is the parents. They are happy that Sanjay Roy has been convicted. They demand a capital punishment, but they are not totally happy. Because they believe, according to them, they are saying that CFSL report and all, more than one person was involved. That is what the parents feel. And not only the parents, The doctors who are the prominent doctors who were in the movement,
Right.
Junior Doctors Association, we have been speaking to the faces. They are also saying that they are not happy and they will continue this.
All right, many thanks to you, Kamalika, for bringing us all those inputs. But remember, the quantum of punishment will be pronounced on Monday. What will be those aspects that will go into determining this case? Will this now be regarded as the rarest of the rare cases? That is something we'll have to, in fact, await on Monday. But let's also listen in to what senior advocate Siddharth Luthra had to say in a conversation with my colleague Ananya. Let's listen in.
This is a case that took to headlines as soon as it happened because a doctor who was, working tirelessly, ended up being in such a state at her own hospital where she was working. Do you think that this case would actually fall under a rarest of the rare category and a death penalty could actually be warranted in this case?
So, Ananya, I'm a little conservative. I don't want to speak about what will happen in court, but yes, I am given to understand that keeping in view the manner in which the offence has taken place, it is logical for us to expect that the prosecution will raise the issue of rarest of rare cases and seek the death penalty. Having said that, the accused is also entitled to raise not only the fact that the event is gruesome and also what are his personal circumstances which should bring it down from death to life. So that's something which is going to happen at the sentencing stage. Once, of course, the sentence takes place, depending on which way it goes, let us assume for a moment there is a death sentence. Then there will have to be a reference made to the High Court, and most likely the accused convict as on today, will file an appeal. The matter will go in appeal to the High Court. A division bench of the High Court will hear the matter, both the reference and the appeal, and determine the matter. If, however, there is a life sentence, because now the conviction is there, it can be only life or death, then it is open to the state and the challenge sentence to say that it should be a higher sentence. Though once the trial court gives life, it is normally, as a matter of practice, high courts don't always interfere. So they do. It's not that it's an absolute rule, but there are limited cases where they interfere. So therefore, what we have to watch and see is what happens and transpires on Monday when the sentencing aspect is seen. One thing has to be noted, that the trial has taken place within 5 months, and it is expeditious justice. Whether it is effective justice or not is to be determined once we have the benefit of the judgment. But keep two things in mind. The first thing is the CRPC and now the BNSS both require trials to go on day to day. The tragedy in our country is that barring states like, excluding Kerala, and maybe some of the northeastern states, we are not able to achieve that purpose. Till we get down to having all trials, whether today it's RG Kar, before it was Nirbhaya, we must try and ensure the efficacy of the justice system, that trial should go on a day-to-day basis, so that the victim side also sees the conclusion, and also the accused doesn't have to linger and wait for years and decades together, and suddenly there is a conviction. So this is something which we have to really work at, and the criminal justice system must effectively work at that. This is, I must say,
So, it is in fact indeed a case that shot to headlines, and you being a criminal lawyer, do you feel that the CBI also, if I take you back to the Supreme Court, the CBI had stated that, it entered the probe on the 5th day, and, there was a lot of tampering that had happened on the scene of crime. Do you think that this might have resulted somewhere or the other in some loose ends as far as today's order is concerned, or do you think that if at all, the CBI would have had that probe in the first place in the instance, there might have been a better case that could have been presented by the CBI?
Anya, this is a crime in a state. The CBI does not have jurisdiction till the state government gives access. Secondly, sometimes we do find that there is a ham-handed approach by the first set of investigators. It has been known to happen in a number of cases. And that can mean that vital clues are lost. But the fact that some vital clues are lost does not necessarily mean that in a scientific, effective investigation, the gaps cannot be covered entirely. Entirely it may not be done, but to a great extent gaps can be covered. Having said that, the CBI is a well-reputed investigating agency which has all the necessary investigative and scientific tools available to it and large manpower. So there is no reason why CBI investigation should not be expeditious, effective and fair. As also there are branches such as the crime branch in state police, in most state polices, which are very, very efficient and effective, and they're known for their professionalism. So in this case, as I see it, and we'll have to see from the judgment, I must of course out that pass both on the authorities in the hospital as also on the initial investigation to say it could have been better. But that is still not meant that the judge has that has benefited the accused, because the court has still found there is enough evidence to prove him guilty.